Hello, everyone. Welcome to part two of the trial preparation workshop. This part, we are going to talk about settlement agreements. So what we're going to cover in this part is what is a settlement agreement, how a settlement agreement can be helpful, what are some challenges in working out a settlement, and what are the different types of settlements. So what is a settlement agreement? A settlement agreement in an eviction case is basically a written agreement stating what each party will or will not do. It's signed by both parties and then presented to the court, and it sets up what will or may happen to work out the case. So when can you start settlement talks? In an unlawful detainer, settlement can be reached at any point before trial. So if it is before trial, after you are served with a notice or eviction papers, it's still a good idea to file an answer, even if you are interested in settling. But after you filed an answer, you can assess what you are willing to offer in terms of settlement, and then contact the landlord or their attorney in writing with your offer. And it should always be in writing. Do not try to reach a settlement over the phone. Make sure it is in writing, either email or even a physical letter is a good idea. And if it is at trial, if you reach the trial date and you haven't reached the settlement yet, then you can still settle right up until trial begins, and even sometimes after trial begins. But the court will typically ask parties to go into the hallway on the date of your trial and try to work out a settlement agreement. If you have money that you want to offer to try to help reach a settlement agreement, you should make sure you have that money prepared in certified funds. And also be sure to bring all the evidence that you have to show the landlord or their attorney why you have a good case and why they should accept your settlement offer. Now, there are a lot of upsides to a settlement agreement. The first being that you can suggest what you want. You can make any kind of offer as long as you're comfortable making it. And whatever you offer, it can't be used against you in court. So feel free to offer whatever you want. And another is that you will know what to expect. And because when you make a settlement agreement, you get what you agree to. And a settlement agreement can also be a good way to protect your credit, your rental history, and any housing subsidy you have. It can be a good way to avoid getting an eviction on your record or a money judgment against you. And it is a guaranteed result. The court is unlikely to change the agreement. Courts actually really love it when parties work out settlement agreements. And so it's very unlikely that if both parties have agreed to the terms of a settlement, that they are going to then say, no, the court won't accept this. And I think one of the biggest upsides of a settlement agreement is you do not have to go through a trial. There is a big risk in going to trial for both parties. You never know what the outcome is going to be. But if you do reach a settlement agreement, then you get what you agree to. So I'm going to talk about some challenges in settlement. The first challenge is, of course, that making a deal with a landlord or an attorney can be difficult. You know, the landlord or the attorney can try to mislead you. They can try to pressure you into accepting terms you aren't willing to agree with. And of course, it's sometimes there are just strained tensions, difficult relationships to work past. But you just need to focus on what it is you're willing to settle for and go from there. And of course, the landlord does not have to agree with your offer. The landlord can say, no, I'm not willing to settle. I want to take this case to trial. Or they can say, no, I'm not willing to agree to what you're offering. How about here's a counter offer and take it or leave it. Now, the court may limit the time you have to work out an agreement on the trial date. So if you do show up the morning of trial and you want to work out a settlement agreement, the court might say, well, you have about an hour, go outside and try to work it out. And if you can't work it out in an hour, come back and we'll start the trial. So just be aware, sometimes there's a bit of a time crunch. And of course, you do need to have set up a strong case to make the landlord agree with your terms. So you need to be able to show that there is some possibility of you winning at trial if you want the landlord to accept the offer that you're making. And here we have a sample scenario with tenant proposing settlement.
As I mentioned in my email, I'm willing to pay $500 additionally every month until I'm caught up on my rent. It's not good enough. I need all the money now, or it's not going to work out. Maybe if you give me a date that you can move out later this month, we can settle it that way.
So now there are three types of basic settlement agreements. The first is a conditional settlement. The second is a move out agreement. And the third is a pay and stay agreement. So what is a conditional settlement agreement? Any agreement that depends on the landlord or tenant taking some action for the settlement to proceed is a conditional settlement agreement. So a move out agreement and a pay and stay agreement can be conditional. For example, the landlord and the tenant can agree on a move out date of 45 days after trial, but the tenant may extend the move out date if they pay an additional month of rent by a certain date. There can be conditions on what the ultimate outcome is. And if you want to work something out with the landlord that includes conditions, you definitely can, as long as the landlord's willing to agree to those conditions. So a move out agreement is probably the most common type of unlawful detainer settlement agreement. A move out agreement allows you to agree on a move out date, and that may also include other details like a sealed record so that you don't end up with an eviction on your record, whether or not you have to pay any of the back rent or any of the rent that came due while the eviction was going on, what happens to the security deposit, whether or not the landlord has to return it, or whether or not you waive your right to the security deposit. And sometimes the settlement agreement can mean that the case will get dismissed if you move out on time. And then also who has to pay the attorney's fees and court costs. And sometimes a move out agreement can include a neutral reference so that if a future landlord calls the current landlord or the prior landlord and asks them for a reference for the tenant, the landlord just has to say that the tenant was a tenant for this period of time. They're not allowed to say anything negative about the tenant. So if you do reach a move out agreement, and if you move out before trial, you should still be sure to attend the hearing. Make sure you show up to court when you are scheduled to show up to court. Don't assume the landlord is dropping the case because you left the property. You have to make sure that case gets dismissed or gets dealt with before you can walk away from it. So just make sure you turn over the keys to the landlord, keep a record, make sure that you know exactly when and how and who you turn the keys over to, and then get any agreement in writing via email or text. Take photos of the unit as you left it. Be sure you take photos after you move out, because a landlord, they might try to charge you for something that wasn't actually your fault or wasn't an issue when you left. So just make sure you do take photos of the unit when you leave. Now, if you do agree to a move out at trial, you should propose a move out date that works for you. Now, the typical pre-COVID move out time was about 30 days after the trial date. I've seen landlords grant more than that. Sometimes it can go up to 60 days. I once had a client who was given 6 months to move out, but that is much less common. And it's always a good idea to ask for a waiver of rent and the attorney's fees and court costs. The landlord might not be willing to agree to that, but sometimes it is cheaper for the landlord to simply waive anything that you owe than go to trial. So it is always worth offering or asking for the landlord to waive that rent and the attorney's fees and court costs. And it's also a good idea to see if the landlord will dismiss the case after you move out. Some cases, some move out agreements require entering a judgment right there. But sometimes you can work it out so that if you move out in time, the landlord will simply dismiss the case and then you don't have to worry about a judgment on your record. And then there is a third type of agreement. It's called a pay and stay agreement. Now, a landlord may decide not to evict if a tenant can pay some or all of the back rent. It's a good idea to have the money ready to offer. If you do want to try to work out a pay and stay agreement, if you're waiting on money, you can ask for a little bit more time to pay the landlord. Sometimes they are willing to be patient, sometimes not, but you just have to work that out with them. Now, the landlord may ask for you to pay the attorney's fees and costs if it is included in the lease. Sometimes this can be only up to $500, or it could be unlimited. It really depends on what the lease says. It's worth checking if you're not certain. And payment plans may be an option. So if you do owe a bunch of back rent, the landlord may be willing to work out an agreement where you pay a little bit extra every month to pay down that back rent. So you should be very careful to agree only to what you can afford, because if you can't afford to pay back the back rent and you default in a settlement agreement or pay and stay agreement, that you will just end up getting evicted. So you should just be aware of that. And future rent should not be included in a pay and stay agreement. The pay and stay agreement should only really be talking about past rent that was unpaid. And of course, again, be sure to get everything in writing. I know I've repeated this several times, but it's always worth getting everything in writing. One of the biggest pitfalls of litigation is oral agreements, or when tenants think, oh, well, we agreed to it over the phone or verbally, and they don't get it in writing. So make sure you get every kind of agreement you ever reach in writing. Thank you, everyone, for listening. For information on how to handle a trial and how to go about a trial date, please watch part 3 of this series. Thank you.